G'day everyone, and welcome to the third video in week 6 of our legal ethics course. This week, as you've hopefully gathered by now, we're looking at the duty of confidentiality, which is one of the duties owed by solicitors to clients. In the first video, we discussed the nature of the duty, and then in the second video, we looked at how the duty is brought into actual practice. Now, in the final video for this week, we're going to look at the exceptions to the duty, the times when you don't have to maintain your client's confidence. We're lawyers. We love exceptions. In general terms, there are 3 categories of exception: the client's consent, limited disclosure for legal purposes, and exceptions to support safety. These are all set out in detail in Australian Solicitors Conduct Rule 9.2, which says that a solicitor may disclose confidential client information if the client expressly or impliedly authorises disclosure, if the solicitor is permitted or compelled by law to disclose, if the solicitor discloses the information in a confidential setting for the sole purpose of obtaining advice in connection with the solicitor's legal or ethical obligations, 4, if the solicitor discloses the information for the sole purpose of avoiding the probable commission of a serious criminal offence, 5, if the solicitor discloses the information for the purpose of preventing imminent serious physical harm to the client or to another person, or 6, the information is disclosed to the insurer of the solicitor, law practice, or associated entity. Now, the first one, consent, is relatively simple. As we've already discussed this week, the client can specifically instruct you to release confidential information. They can also impliedly do so, but you're absolutely crazy if you rely on implied instructions to release confidential information. Get the instructions from the client explicitly, preferably in writing. The second category of exceptions are those which exist for the purpose of law. Let's start with exception number 2, where the solicitor is permitted or compelled by law to disclose confidential information. There are a range of organisations, such as the Crime and Corruption Commission, which have been given by the Parliament quite extraordinary powers to demand information. For instance, subsection 74(2) of the Crime and Corruption Act allows the Commission to require the person, within the reasonable time and in the way stated in the notice, to give an identified Commission officer a stated document or thing that the chairperson believes on reasonable grounds is relevant to a crime investigation. So what do you do if the Crime and Corruption Commission comes along and demands under section 74 access to your files regarding a client? Well, the Queensland Law Society has released some guidance, but ultimately, if an organisation is authorised to demand that information, and if they make a proper demand, you're not breaching your duty of confidence by complying with that demand. Next, exception number 3 allows you to disclose client information in a confidential setting for the purposes of obtaining ethical advice. Remember in week 2 when I introduced you to the Queensland Law Society's Ethics Centre? Well, there would be no point even having an ethics centre, would there, if you couldn't go and talk to them about your ethical problem, because in order to talk about your ethical problem, you might have to disclose confidential information. So, if you disclose information to someone else specifically in order to seek ethical advice, you're not breaching the duty of confidentiality. Similarly, if there is a conflict between your firm and the client and you need to brief your firm's insurers, then there's no breach of the duty of confidentiality if you provide those materials to the insurer. In the same way, if your client complains to the Law Society regarding your services, or worse still, if they actually commence an action against you, then you're going to be able to refer to confidential documents in order to defend yourself. This was the case in a matter called Beneke and the National Australia Bank, in which Justice of Appeal Clark regarded the point as so fundamental that it came as something of a surprise to find no authoritative judgments on the point. I have to tell you though that in my time in practice I've never had to rely on any of these exceptions. The CCC has never come knocking, and the clients have never tried to sue me. I have sought the ethical advice of the Ethics Centre, but so far that hasn't required me to disclose confidential information. The third group of exceptions come in exceptions number 4 and 5. you're allowed to breach confidentiality in order to prevent imminent, serious physical harm to the client or some other person. And you're allowed to breach confidentiality in order to prevent the commission of a serious criminal offence. Let's start with self-harm issues. If you have a client who threatens any sort of self-harm, then you are allowed to breach confidentiality in order to seek help for that client. Some level of discretion is necessary here. Guidance from the Law Society says that you should consider the seriousness of the potential injury, the imminence and likeliness of the harm occurring, and the absence of other feasible ways to prevent the harm. With all due respect to the Law Society, I think that's pretty dangerous advice. It can be very difficult to honestly determine the likelihood of harm occurring. If a client is in your office and they're telling you that because they can't see their kids this weekend, they're going to commit an act of self-harm, or worse still, if they're saying they intend to commit suicide, then unless they're very clearly making a tasteless joke, it's probably best to err on the side of caution. Ideally, you should tell them that you feel you're now under an obligation to take steps for their protection, and then call for help. 000 and the ambulance are probably the best option. Even in this situation, however, it's not open slather to ignore the client's right to confidentiality. You can only reveal the confidential information that is necessary in order to get them the help that they need. If the client indicates an intention to commit a criminal offence, particularly an offence of violence against another person, then you are not required to preserve the confidentiality of that statement. The Law Society's Ethics Centre suggests that you consider the following questions. What is the prospect that the potential harm will occur, and is it imminent? Are there other ways that the potential harm could be prevented? Under what circumstances has the information been obtained? How rational is the client? Are you aware of any previous threats? Is the client merely letting off steam? Again though, the difficulty is that you don't want to find yourself in the position where you've passed off a threat on the basis that the client was just blowing off steam, then a couple of hours later you're reading about them on the news. Often it's going to be safest to err on the side of caution. Tell the client that you have to take the threat seriously. Advise the police. Advise your more senior practitioners. The client is almost certainly going to terminate the retainer and sack your firm, but that's fine. So, we're almost at the end of week 6 of our legal ethics course. This week we've been talking about the duty of confidentiality to the client and the fact that information provided by a client for the dominant purpose of legal advice is privileged information. We've talked about how that operates in practice, and in this third video we've learned that the duty doesn't apply if the client releases you from the duty of confidentiality. It doesn't apply if there's some reason associated with processes of law that require or allow you to disclose the information, and it doesn't apply if you're disclosing the information in order to prevent serious harm to the client or serious harm to some other person. Next week we're going to explore another aspect of the solicitor's duty to the client, the duty to avoid conflicts of interest. And you'll find that the duty to avoid conflicts of interest is directly related to the duty of confidentiality. Hey, we're halfway through the material for the course. See you next week.